Hello, my name's Jamie Gamble. This talk is being recorded in July 2020 as we're just starting to come out of the lockdown due to the COVID pandemic. A lot of the conversations we're having as a society at the moment seem to surround wrestling with competing interests, and in particular balancing our freedom and independence as individuals against the risks that exercising that independence can cause to us and to society as a whole. And it seemed to me that there is a parallel there in personal injury and clinical negligence litigation that's worth considering. An issue that frequently arises in more serious personal injury and clinical negligence litigation is how you balance the autonomy of a claimant and the risks that they're exposed to and their independence, particularly with regards to the care regime that they require. How far a care regime should go reasonably to restore the autonomy and independence they may have had before, and how you balance those needs against the need for spontaneity and the desire for personal independence. For example, what if a claimant can manage with one carer for most of the time, but for certain transfers or to access the community they need two? Does that mean you need a care regime that provides for two carers to be present with them all of the time, or can you plan around things? What about independence? Epilepsy or the risk of falls, it seems to me, are good examples of this. How do you balance the risk of something quite serious happening to a person, even if it's only a very occasional risk, against the loss of independence and intrusion of having someone there present all the time to guard against that risk? It's often also the case that claimants can find, in my experience, the presence of carers very intrusive. How do you consider the risk, for example, that someone with uncontrolled epilepsy may die if they're left alone and they have a seizure, against having someone with you 24/7 in your home all the time for 99.9% of the time when they won't be needed to do anything at all? Is an epilepsy watch sufficient to alert someone to attend you? Or is there even still then a greater risk that someone will die if someone doesn't arrive on time? And how do you look at those sort of issues? So we're going to examine some of those tensions and how they've been decided in some of the reported cases. And then I'm going to go on to talk briefly about hydrotherapy claims. And then Matt Brunning is going to follow up with some further thoughts on how the COVID pandemic might impact upon care claims now and in the future more generally. Let's start, however, by looking at some of those cases dealing with the issue of autonomy and taking us initially back to the simpler days of 2007 and the case of Massey and Tameside and Glossop Acute Services. Massey was a severe cerebral palsy case where total overlap care was awarded on the grounds that anything less than that to enable transfers at all times of the day would adversely affect the claimant's autonomy. So in other words, if you needed to do something at a particular time, there needed to be two people there to meet that need, even if most of the time that second carer wasn't needed. So that's a helpful case for claimants because it emphasises the need to restore autonomy to an injured person as far as possible. In that case, Mr. Justice Tier rejected the defendant's submission that as the claimant's autonomy could not be fully restored by any care regime, a regime that tried to give him as much autonomy as possible was excessive. And in doing so, he said, the fact that it is not possible to restore full autonomy to Joseph does not appear to me to be a good reason for not adopting that care regime which restores autonomy as far as possible or realistic. So the claimant's substantial care regime in that case was awarded in full to allow for a second carer to be present at all times to deal with any unpredictable needs that Joseph might have. So it's a helpful case for claimants in terms of the argument of putting them back into the position they would have been but for the negligence, and that meaning giving them as much autonomy and spontaneity in their lives as possible. There's a similar result in another CP case that was decided in 2008 called XXX against Strategic Health Authority, where the fact that the claimant required two people to move him led to two carers being allowed throughout the day, even though he didn't need two carers so much of that time. However, Mr. Justice J in the more recent case of Farrugia took a rather different approach. That was a case involving severe brain damage and epilepsy following a road traffic accident. And the curtailment by the court of the regime that the claimant was asking for in that case of two commercial carers at all times was only modest because it provided for reliance on a second gratuitous carer for some of the time. But in making that curtailment, the judge said this: "I do not consider that Jack's personal autonomy is overridden or the dictates of spontaneity are unreasonably quelled by providing a regime which presupposes a modest degree of pre-planning and organisation. This, after all, reflects the realities of ordinary life." So the judge is essentially saying there that complete autonomy and spontaneity does not have to be provided for, and it's reasonable to do some planning in advance. And for my part, I think there's something in that. It may be because I'm middle-aged and have children, but I can't remember myself the last time that my life entailed any spontaneity at all. But let's move on to look at a few cases that deal with balancing particular risks that can occur for certain claimants as a result of their injuries with that need for independence. The first of those that I want to talk about is the case of Davies and Bradshaw. In that case, the claimant was a partial tetraplegic who was at risk of falling, and indeed had fallen and injured himself previously when left alone. Mr. Justice Wilkie reduced the live-in care package that was already in place and functioning, which was designed specifically to minimise the risk of falling, and in doing so said this: "Whilst falling for someone with the claimant's condition is potentially hazardous, I accept the assessment of Dr. Bird that the present enhanced risk of falling is not on its own sufficient to justify live-in care." The claimant's argument for live-in care failed sufficiently to take account of the contribution which a person's sense of worth and well-being makes to their functioning, and the extent to which physical activity, contributing to a general state of fitness and stamina, has a positive impact upon their functioning. So here we can clearly see the court taking the view that notwithstanding that there was a significant risk of injury if a significant care package was not provided, a live-in carer was not justified, as that risk was balanced by the greater independence that would be gained from a lighter touch regime. There was a slightly different result in the case of C against Dixon, which was a case of severe brain damage where a claim for 24-hour care and very extensive case management was advanced. The defendant in that case submitted that this went beyond what was required and pointed to evidence that the claimant had been resentful of the care package in the past and had previously enjoyed free time on their own. In that case, Mr. Justice King essentially split the difference. The claimant won on 24-hour care as the risk of leaving her alone were potentially very high. However, this could include non-commercial support from her partner overnight and some free time when her partner was at work with a carer available on the phone. Finally, on this issue, the case of Ali and Caton from 2013 was a moderate brain injury case where there was arguably an attempt by those representing the claimant to wrap a young man in cotton wool in terms of the care that was claimed, and the care that was claimed was rejected. Only 15 hours a week of care was awarded in that case, and Mr. Justice Stuart Smith said that the purpose of the future care regime should be to provide sufficient support to enable the claimant to pursue a structured and constructive existence as far as possible, reinforcing constructive routines and being available to exist when he is confronted with the new, the unfamiliar or the complex. That was upheld by the Court of Appeal on appeal, who concluded that the judge had achieved a sensible balance on all the evidence. Overall then, I think we can see increasing signs of the courts having sympathy with arguments being raised by defendants to reduce substantial care claims on the basis both that there are limits to how far compensation should go. Overall then, I think we can see increasing signs of the courts having sympathy with arguments being raised by the defendants to reduce substantial care regimes on the basis both that there are limits as to how far compensation should go and that there is a limit to the degree of autonomy that it is reasonable for claimants to expect, and that they should expect to accept some degree of risk, particularly if removing that risk would have a negative impact on their personal independence. Finally, before I hand over to Matt, just a short word about hydrotherapy pools, which seem to be particularly in vogue in larger claims at the moment. Whilst they're frequently claimed in cases, they don't in fact have a very good track record of succeeding at trial. Whiten is a good example of the usual approach. This was a very severe cerebral palsy case, but the court rejected the claim for a hydrotherapy pool, stating that the claimant had not established a real clinical need for the pool at home, and said that the claimant could purchase accommodation near to a public pool. Subsequent decisions have given some more cause to hope for claimants in relation to these sort of claims, and where they're succeeding, it seems to me, is where arguments are switching to the relief of symptoms as opposed to there being any therapeutic benefit being the reason for these pools. So it's not really hydrotherapy as such at all, so much as pain relief by being immersed in water that's the argument that's succeeding. There are two cases in 2015 where pools were allowed. The first of those, case of A, the pool was allowed in what was described as the exceptional circumstances of this case, not for any physiotherapy reason, but because of the agony of painful spasm which could only be relieved by total immersion in water, including at night when the claimant would be got out of bed by her carers. In Bradshaw, the claim was not presented on the basis of hydrotherapy at all, but on a real and tangible psychological and physical benefit that swimming would give to a claimant who had already moved into long-term accommodation with no pool nearby. But the judge in that case, whilst it may seem a generous one, it's worth noting that the judge did say that the decision in that case should not be seen as a green light for claiming a home-based pool in every case. And the fact that that was not taken as a green light can be seen in the subsequent cases of HS and AB, where the difficulty in both cases the claimant faced was that the judge was not convinced that the pool will be used with sufficient frequency to justify the expense. It's worth noting, though, that in both of those cases, a not insignificant sum of £5,000 and £2,000 respectively was allowed for hiring a private pool instead. So it's worth remembering to claim that in the alternative. And if you're going to advance these claims, it seems to me the key is to make sure you have the right arguments and the right evidence. The main piece of advice I would give would be, as I've done in other cases, to obtain a video showing the relief that the child obtains when in the water. That was crucial to the decision in A, where the pool was awarded, because the judge explicitly said in his judgment that it's seeing the relief that the child had in the water on the video had moved him from an initial position of scepticism. And also be able to show that it's reasonable to have that facility at home, such as for reasons that there being no pool nearby of a public pool, or be able to argue that it's necessary to have access to the pool for pain relief at night. It also seems to be that it may be the case that the COVID-19 pandemic will support the need for home provision in the future, if the current position continues. At the moment, attending a public pool, of course, is not an option. Matt is now going to pick up on some of the other effects that he thinks this pandemic may have on care claims, and I'll pass over to him.
Hi, I'm Matt Brunning. I'm going to pick up on some of the points Jamie's just made and to look at how the impact of the COVID-enforced lockdown is likely to impact on claims for care regimes, case management and therapies in a post-COVID world. As Jamie's review of previous cases has outlined, there will be undoubtedly a wide range of judicial findings. Obviously, if I had the gift of foresight, I'd have retired by now on my winnings. So rather than predict the outcomes, I'm aiming a little lower and I'm going to attempt to identify the likely areas of dispute. One thing we're all aware of is the disproportionate impact that COVID had on those in the caring professions. Inevitably, this had knock-on effects on those requiring care in whatever format. We're not yet far enough into our recovery from this virus to have reliable data to show precisely how this impacted on the provision of care societally. And macro data will mask the huge variations of outcomes for individuals. Even with good data, there will be a range of opinions as to how best to mitigate the effect in future, whether against a second spike, a mutation of the virus, and so forth. There are bound to be areas of dispute as to the likelihood of such an event recurring. Is this a once-in-a-century event, once in a generation, or will we have to live with the heightened risks for much of our time? Dependent in part upon the answers to these questions will flow others. For each claimant, what is the care regime most resilient against similar future events? To what extent is a change in the regime reasonable mitigation of the claimant's needs, and to what extent over-provision? What will be dealt with by way of contingency, and what by the way in which the care package is structured? Will there emerge a difference in the most commonly recommended care packages for for instance those with a spinal cord injuries as opposed to those with acquired brain injury. I would suggest that our experience of the impact on care regimes, therapeutic provision and case management changes to date can at the very least inform us about where the battlegrounds are likely to emerge. One of the most notable aspects of the early phase of lockdown was the difficulty we all had in meeting our own basic needs. Shopping, for example, was an event that needed to be planned. We had to adapt to new procedures. It was more time-consuming, and for many, it resulted in increased anxieties. Those effects were hugely magnified for those with additional care needs. Those with respiratory vulnerability or other vulnerability had to shield themselves, with every interaction increasing the risks they ran, probably also impacting upon their mental health. This reduced their capacity to access the community at all, resulting in greater domiciliary support needs, where those could continue to be met, in order to ensure that contamination risks were reduced or eliminated. By contrast, those with cognitive problems were often unable to adapt to new procedures or to understand the importance of hand washing, maintaining appropriate social distancing, and so forth, bringing bewilderment, increased risk of confrontation, and the like. The results varied. For some, greater support in order to maintain their independence, but for others, those safeguarding issues led to a need to move temporarily to a place of safety, often away from their loved ones, in order to ensure that they did not pose a danger to themselves or to others. As well as the obvious spike in case management costs that accompanied the first spike of COVID infections, this raises, as Jamie has spoken about, a real tension between the individual's desire for autonomy and independence and their best interests. In addition to the increased care needs of individuals, varying dependent on the nature of their needs, we've seen massive differences in whether and in the way in which care needs have been met. In the statutory sector, for example, cared for children had to be locked down, resulting in whichever support workers happened to be on duty at the time having to isolate with those children for a fortnight. For some claimants, the prospect of lockdown saw a number of their carers leave where they were living in order to return to their families, elsewhere in the UK or in the wider world. For those fortunate enough to remain able to have their needs met, there were changes to the nature of the regime. Shift changes or handovers naturally increase the risk, but handovers also take longer, given the need to reduce touching items that have been used by others, shift logs, computers, items of equipment and so forth, as well as the need to wear PPE for many tasks. Some opted for fewer staff working longer shifts. Some went further and had carers living in for a week at a time. It won't be too long before the increased costs can be calculated from available data. But it is likely that the possibility of such demands being placed upon a carer or support worker in future will impact on the number willing to undertake the work in the long term, and thus the cost of such provision. Will the court accept a premium rate would be a reasonable way to obtain the services of those willing to take that risk, to provide that service in the long term? If so, will it be reasonable to employ them permanently, or is it just a contingency to be allowed against that need, just as currently allowances are made for periods of ill health predicted to occur cyclically each year or each decade, and thus requiring living care for a period rather than shift workers. Often an area of dispute is over whether support workers should be directly recruited or hired via an agency. I wonder whether the after effects of COVID will tip the balance on this aspect of cases. Direct employment could be said to render the claimant economically more vulnerable to a future epidemic in a number of ways. Carers and support workers already need regular training on a number of important features of their role, and that's factored into the care regime. COVID has just introduced an additional layer of complexity to those training needs. A future epidemic with different features or greater understanding of this one would impose a significant further cost. With direct employment, the claimant is liable for those additional and unpredictable costs. If training is provided via an agency, there will be an increased hourly rate to cover those background costs, but in a manner that's predictable and factored in. Similarly, the need to isolate. If a directly recruited employee is forced to self-isolate away from their work, then presumably the employer will be liable for their wages in addition to the cost of a short-term replacement. Whereas with agency provision, the risk falls elsewhere. That's not to say that agency provision is without its downsides. Where support workers cannot work for whatever reason, agencies are not necessarily better placed than a case manager to source replacements during an epidemic. Even agencies linked to leading charities such as Headway struggled to meet demand during the first month or two of lockdown. And all of these factors have a knock-on effect on the need for therapies and case management. Those case managers who saw the pandemic coming ensured that their clients were as well prepared for life during lockdown as possible. This meant increased case management and OT time, training them in the skills necessary to permit some form of remote support, for instance medication calls and so forth. Just as there are always spikes in case management around significant life events, such as moving house or having a child, an epidemic had the same result. Courts will have to build this in some way in the future as a contingency. The question being, as I said earlier, what is the level of risk to be allowed for? Even with this provision, there will be further impacts. As well as direct OT support and training for support workers, there will be a need for intensive therapeutic input to help rehabilitate after periods of enforced lower provision, whether of physiotherapy, neuropsychology or whatever. It will be interesting to see to what extent this tips the balance between domiciliary provision of such therapies as opposed to community provision. Obviously the former comes at a cost, but if COVID remains a risk, such that it's reasonable for a claimant to avoid as many unnecessary interactions as possible, in the more finely balanced cases, the distinctive defensive instinct will be hard to characterise as unreasonable. And talking about what Jamie was about hydrotherapy pools, that's an area in which I would suggest it would be particularly pertinent. As he also pointed out, much will depend on the evidence adduced, and I'd suggest that infection risk and the claimant's approach to it will be an additional aspect necessary to evidence. No doubt the strength and relevance of all of these arguments will depend in large measure upon the course the virus takes over the next few months. Whether, as feared, we have a significant second spike giving rise to a prolonged period of further lockdown. Whether a vaccine is developed, if so, the efficacy of it, and the scientific advice as to the residual background risks. But, as I said at the outset, if I had the gift of foresight, I'd probably be retired. So for now, all I would think we can usefully do is to stay alert about relevant issues.